Justice with Judge Mablean will be life because in everything we do, it involves the law. You came to court to testify about what you heard, what you saw, and what you know.
She's fair.
I don't have a hearing problem. This ear works good. This one works even better.
She's firm.
I'm not responsible for that ticket, and I'm not going to pay for it.
Who says you're not going to pay for it? I'll make that decision, not you.
She's honest.
What you have to say?
All I have to
Nothing.
say.
This is Justice with Judge Mablean. Kayla Cranshaw is suing Lori Martinez in the amount of $10,000. Ms. Cranshaw claims Ms. Martinez defamed her on social media after she performed a cosmetology procedure on the defendant. Ms. Martinez says she posted a picture of herself with an infection, but claims she didn't mention Ms. Cranshaw by name. Ms. Martinez is countersuing for $795.
In the matter of Kayla Cranshaw versus Lori Martinez, I understand that Ms. Cranshaw is suing Ms. Martinez for $10,000 because of injuries to business loss, because she posted a picture about your work and claimed that you're terrible at microblading. And the counterclaim is $795 for medical bills as a result of the microblading that you posted about, right? Okay, Ms. Cranshaw, let me hear your claim first.
Yes, absolutely, Your Honor. I am a trained cosmetologist. I'm also trained in microblading and microfeathering, and really happy in general with my business up until I met Ms. Martinez.
Maybe you want to explain to me and whoever else that may not quite understand the difference between microblading, or what is microblading, and microfeathering.
Yeah, microblading and microfeathering are similar.
Okay, wait a minute. You talk faster than me. So you have to slow it down just a little bit.
Sure. They're both permanent makeup that go on your eyebrows in small strokes and small incisions that make your eyebrows appear fuller. Microblading is a little bit more intense, and microfeathering is what I suggest to people who are getting it done for the first time because it's a little thinner, though you can come back for another treatment as well.
And how long does this last?
It lasts up to a year, microfeathering usually, and microblading lasts a little longer.
So you just go to bed and wake up with nice eyebrows every day?
It's pretty amazing.
Ooh. And what happened with Miss Martinez?
She came in to be consulted, and I suggested she get microfeathering done because it was her first time, and she came back 2 weeks later and had the procedure, and it went great. It was very routine. She didn't have any sort of adverse effects in the room, and I gave her some very specific instructions.
What were those instructions?
Those instructions were to not partake in activities that caused additional sweating, and to...
what do you mean additional sweating?
Any sort of activity that would cause you to sweat, like walking or running or playing
For
tennis.
how long?
For 2 weeks.
Oh, I could never do that.
I know.
Well, I'm trying to sweat getting dressed. Go on. What else?
And to put ointment on her eyebrows 2 to 3 times a day for the next 2 weeks.
Any particular type of ointment?
Yes, the ointment that I gave her.
And what type of ointment was that? You provided it.
Yes.
And what was that? What was it?
It's an antibiotic ointment. The self-care afterwards is honestly the most important part of the procedure.
What about washing her face? Can she wash her face and wash it?
Yes, she can wash her face, but we also suggest that she blot as opposed to rubbing, just to prevent any sort of further irritation.
All right. So now what happened, Miss Martinez?
So to say that I'm defamatory for simply posting a photo of the reaction of the services that were provided by the plaintiff is insane. Let me start off by saying that.
So you did post the photo?
I did post a photo, but I didn't attach her name to it. I posted the photo and the caption was, "Unexpected visit to urgent care, no microblading."
Okay, so what happened?
I went in for the procedure, all went well. We got along great. I loved my eyebrows post-procedure. I got home, I had to walk my dog, and I did sweat a little bit. So I came home and I did some blotting on my face like she suggested, and I went to bed. When I woke up in the morning, I had irritated eyebrows. So I decided to apply old ointment that I had in my medicine cabinet.
How old?
I don't know, Your Honor. It's been in there. I'm not really sure. So I applied it when I woke up. I was broken out into irritation. My eyebrows were on fire. So in the midst of that, on my way to urgent care, because I decided this is something that needed medical attention, I posted a quick selfie to my friends. and just saying, you know.
Well, not just to your friends. If you post to whoever is on your page.
Yeah,
whoever follows you.
Yeah, so whoever follows me, which is, you know, I don't have a big following,
Your Honor, it went viral.
Just hold on.
Okay.
But those weren't my intentions, Your Honor. You know, it was surpurping to me to see
you
how
posted
much.
a selfie on your social media pages.
Yes, and then I hashtagged ouch, hashtag beauty should not be pain. So I didn't
You
tag
didn't call
her.
her your name.
No, I didn't tag her. I didn't, you know, I mean, people did privately message me and ask me where I got it done, so I was honest. But I didn't go out and want to, you know, tear apart her business or her name. Those were not my intentions.
I see.
Coming up on Justice with Judge Mablean.
I didn't really sweat, Your Honor. I mean, I literally just went for a walk to my dog. I didn't go to the gym or anything like that, so I don't see
Well,
how
honey,
this...
some people can sweat getting a walk for the dog. I just told you, I sweat getting dressed.
And later,
He did agree. I did send him pictures on my
He's
cell phone.
relying on you that this place was a good place to have an art exhibit. He agreed.
we're back with the case of Kayla Crenshaw, who is suing Lori Martinez for loss of business.
Why did you use the old ointment from the cabinet when she had given you ointment to use?
To be completely transparent, Your Honor, I forgot that she had given me the ointment. I didn't think it would be a huge difference between that one and the one that I had in my medicine cabinet. After the appointment, I kind of just threw it in the back of my car because I was in a rush, and I just didn't put two and two together when I was under you know, pain. I just kind of reached for the closest thing, and that seemed to be the...
And her ointment is in the back of the car.
Yes.
You went and had a procedure that you'd never had before. The lady explains explicitly to you what you should do, should not do, and you violated both.
Yes, I mean...
You sweated, and you used old ointment, and she said use this ointment and gave it to you.
I mean,
you
it
didn't
wasn't-
even have to get a prescription. You didn't have to buy it. She handed it to you.
I mean, I didn't really sweat, Your Honor. I mean, I literally just went for a walk to my dog. I didn't go to the gym or anything like that, so I don't see
Well,
how
honey,
this...
some people can sweat getting a walk for the dog. I just told you, I sweat getting dressed.
I typically don't sweat, Your Honor, so I didn't see this as being a problem. So, I mean... It's
Well, you may not have seen it as being a problem, but she had told you that sweating was a problem. Mm-hmm. Okay. And you had never had it done. So how could
Yeah.
you see anything being a problem? Because you didn't have any experience in
Well, I
this.
have a few friends that got it done, and their experience in recovery
But you
was
know
pretty
what? That's
seamless.
what happens when people go to get things done, procedures. The person who's the expert, the person who has the experience, the person who has the training, if you're not going to listen to them, then why bother to go get it done by them?
I completely understand, Your Honor, but in regards to what she's suing me for, I didn't bring her name down. I didn't attach her business to my post.
So now you want her to
I
pay
wasn't blaming
for the
her.
$7.95 for your medical costs?
Yeah, well, now that I'm here and she's inconvenienced my day and she's gone out of her way to bring us into this courtroom, yes, because honestly, the results that I got from the microblading was what I expected. I was already, you know, inconvenienced by spending the $600, going to urgent care and spending $195.
But it sounds like it was what you expected. When you came off her table, you were well pleased. But I don't understand why you think that she defamed your name and she caused your business to suffer. You're going to tell me that this woman doesn't have the right to post a picture of herself, her face, saying microbladed, this is what happened to me, no more microblading for me. That's what she said for her. She's sharing her experience. Why can't she do that?
Because the problem is that the statement is false. The statement says that microblading is the cause of the issue, and the
it didn't.
cause was actually, yes, it does, no more microblading, not no more improper use of self-care afterwards, and that's the cause.
Well,
the
but for her, it meant no more microblading.
Just for me personally. Not
Sure, but
for...
it's also, I mean, I guess you can read it several ways. I think most people read it as an instruction, don't get microblading. And actually, that's what ended up happening.
And why can't people read that? Why can't, in freedom of speech, First Amendment rights, why can't I say no more microblading? Why can't I even call your name and say don't go to her shop?
You can, but it's defamation if it's false, and it's defamation because she posted it, and because it led to my business almost collapsing.
It wasn't defamation because it was not false. She did have a problem with getting microblading.
If she had followed my instruction and used the ointment that I had given her, it would have been a totally fine recovery. So it's not
That's
the
not a guarantee,
microblading,
though.
it's
You're
the way
saying
she
that,
had
but
used
that's not
you
necessarily
used an old
true.
ointment
Okay, and
that you had an allergic reaction to. So how is it
That's
my
why I'm
fault?
not
reaction
making her-
started prior to me using that ointment.
She used the old ointment. That's why I'm not making you pay her medical bill. Because she used the old ointment. And because she didn't follow your instructions. But I know that she hasn't defamed you. You have to prove that it was because of her actions, just her, that you lost your business. How do you prove that?
I have
Who
emails.
told you that I didn't come to her because of her?
I have emails, Your Honor, from both Kate Collins and Lindsay Scathers
That's hearsay.
on the 24th and the 29th of August.
That's hearsay.
They specifically cite
That's hearsay. Where are they?
right here.
Where are the people?
Oh, they're not here right now.
Ooh, that doesn't come into this courtroom.
They haven't yet. They haven't talked to me since. I've lost their business at least, and then so I lost both of them, and they specifically cited the social media post as the reason. And then in the subsequent days, I have it right here, all of the cancellations that happened subsequently. There were
That
14.
say, and I'm canceling because of what Ms. Martinez said.
No, those are the only two that specifically say it. But you know, it's a natural conclusion.
No, it's not a natural conclusion by law. You have to prove that you lost business. You have to prove that but for what she did or said about you specifically, you would have had that business. You have to prove that she deliberately and intentionally said something about you that was false. It was not false. Microblading at your salon did cause a problem for her. It wasn't the only thing that may have contributed to it, using the old ointment, but she did have a problem. So it's not a false statement. But more importantly, you haven't proved that you lost the business because of her. Those statements are out-of-court statements offered to prove the truth of a fact, which is hearsay, which is inadmissible.
Okay.
So as far as I'm concerned, there's not a statement right there. Both claims are dismissed.
All rise.
Judge Mablean has ruled. Both claims have been dismissed.
Maybe I didn't treat it the best that I could, but it was definitely a result from your procedures.
I wish those women had been able to come in because you would have gone down.
Coming up,
I mean, I didn't expect him to cancel on us at the last minute.
I know you didn't expect it, but do you understand my question?
Justice with Judge Mablean. Jonas Alves is suing Christopher Perez in the amount of $5,000. Mr. Alves claims he had few sales at his photography exhibit because Mr. Perez booked a location with little foot traffic. Mr. Perez says the original location he contracted with canceled at the last minute and claims the new space came highly recommended.
Jonas Alves versus Christopher Perez. You're suing him for $5,000 for what you say is the leasing price you had to pay for a building to have an art exhibit, right?
Yes, Your Honor.
Okay, so tell me about it.
Me and him have an agreement working with each other for 2 years, and he finds me locations in other states around here since he said he could help expand my business.
Finds you locations for what?
For
business?
photography, I'm a photographer. I sell pictures.
And what happened this time?
He booked us a location down in Miami on 2nd Avenue. It's a very big location. From what I was told, it's a lot of foot traffic. A lot of people could come in and out. A couple of days before, it got canceled. So he then said he found a new location and assured me that it would still be the same amount of foot traffic, the same people are going to be coming through. And the week of the whole thing, my numbers were down.
So why did the people cancel, Mr. Perez?
Well, unfortunately, the owner of the first location, he just canceled on us because there was a grace period a week before.
Why would you book a facility that allows someone to cancel within a week of the exhibit?
I mean, I didn't expect him to do that, to cancel on us at the last minute.
I know you didn't expect it, but do you understand my question?
Coming up,
He did agree. I did send him pictures on my
He's
cell phone.
relying on you that this place was a good place to have an art exhibit. He agreed.
closed captioning provided by. We're back with the case of Jonas Alves, who is suing Christopher Perez for breach of contract.
Okay, so you found a second location.
And while I went down there 3 days before booking the second location, and there was a big parade, a lot of foot traffic, and I thought this would be perfect for him. And it turned out that the parade was only happening.
So you
that
didn't know
time.
anything about Miami and this gallery area either, huh?
No, I'm not familiar with Miami, but I do know people there. They suggested this second location for me, and I just went with it.
And in the last 2 years, what was the average number of pictures he sold for each of the exhibits you had booked?
He was doing pretty good. I don't know the
what
exact
pretty good
number,
is.
but he was happy with it. He didn't have any
Okay,
problems.
do you know what
Your
was your
Honor,
average?
I have a statement that shows from one of the previous ones I worked on. I do
Well, what's your average? You've been working with him for 2 years.
14,000 a week on selling my pictures.
Okay, that doesn't tell me anything. How many? Okay, 14,000 a week is
Yes,
the
ma'am.
average, and you were going to be here for a week.
Yes, ma'am.
And how much did you earn?
I earned 3,000.
And you attributed to him because of the location. Where's your contract between the two of you?
I have that right here too.
Let me see.
Yeah, but
I'm not, Your Honor, I'm not suing him for the guarantee that I'm gonna sell money. I'm suing him for the fact that he's supposed to be guaranteed this venue is going to be in an area that's highly populated. The new location that he found, he didn't do his research on it. It wasn't high in traffic. So instead of my 40 to 50 a day numbers of people coming in, I only had about 10 to 15. So if they came in and didn't buy nothing, I would just have to eat the cost. But it's the fact that you didn't do your due diligence, and I just didn't have the traffic come in.
Judge Mablean's verdict when Justice with Judge Mablean returns. Promotional consideration provided by
It was negligent on your part when you booked the first contract, giving the owner a week's notice to get out of it. And then you book a second place without knowing anything about the facility. You didn't do what you should have done as a manager in booking a place.
Your
I think
Honor,
you failed in your duty.
he did agree. I did send him pictures on my
He's
cell phone.
relying on you in justifiable reliance upon your representation that this place had sufficient foot traffic and was a good place for an artist to have an art exhibit. He agreed. He didn't know anything about it. He justifiably relied upon you. And that reliance was not good. Since you're trying to book him in all these different places, you need to go do some homework way in advance to find out the best places in the city.
Unfortunately, I've known people in Miami and I trusted them. I guess that they told me that would be a perfect place for his gallery, but
Okay.
I just did my best and
No, you didn't do your best. That's why I'm charging you with it. Judgment for the plaintiff.
All rise.
Judge Mablean has ruled in favor of the plaintiff. The defendant has been ordered to pay $5,000.
As a booking agent for artists, this just can't happen again.
I did my best and I plan on doing even better next time.